Hello everyone, I hope you're having a good day and you're staying safe. I'm Sesa Gill, a legal intern at LEXIS and Company, and today I'm going to be talking about the doctrine of privity of contract. Now, this doctrine talks about that only the parties to the contract can enforce the contract or take actions against it. A person who is not a party to the contract but receives some benefits from the contract is not entitled to take any enforcement actions. The doctrine of privity means that a court cannot that a contract cannot, as a general rule, confer rights or impose obligations arising under it on any person other than the parties to it. For example, if a party A promises a party B to pay 100 rupees to the third party C, thus A and B can sue each other in case of breach of contract. However, C cannot sue the party, and this is known as the privity of contract. Different courts in India have different views regarding to the concept of privity of contract. There have been many cases where the third party is not able to sue in case of a default due to the operation of rule of privity of contract, while there have been some cases where the rule of privity of contract is completely disregarded. Hence, the privity of contract is a topic of great debates among scholars. Now, the next topic that I'm going to be talking about are the essentials of privity of contract. The first is a contract has to be entered into between two parties. The most essential element, the most essential element is that there has to be a contract between two parties or more. Um, Parties must be competent and there should be a valid consideration. Competency of parties and the existence of consideration as are prerequisites for the application of this doctrine. There have been a breach of contract. There has to be a breach of contract between one party. The breach of contract by one party is essential requirement for the application of doctrine of privity of contract. Only the last essential is only parties to contract can sue each other. Now, after the breach, only the parties that are in the contract are entitled to sue each other for non-performance of the contract. Some exceptions that are part of the doctrine of privity are agency. In a case of a principal agency relationship between the third party and the contracting party, wherein the third party, that is the principal party, has expressly contracted that the other has to act on his behalf, and the contracting party, that is the agent, contracts consists the to act in that manner. The third party, being the principal party, can also enforce the contract. The second exception is trust. In a case, one party A promises the other party B for the benefit of C. Although being the third party C can enforce the contract as B is a trustee of C. A can become a trustee of the other person if he fulfills the following criteria: that the party should have the intention to create a trustee, and it should have this intention should be beneficial as particular to the third party and not all the three parties. Um, the third exception is that collateral contract. In a case of contract is accomplished by a collateral contract, then a party is to the collateral contract can enforce the contract. For example, when when a party A purchases goods from party B, there is a contract between A and the manufacturer of the good. The doctrine of privity is a subject to various debates despite being accepted in many jurisdictions. Now, in conclusion, I would like to say that from the above discussions that we've had, and we've talked about the essentials and the exceptions, we have seen that although only parties to contract can sue each other and no stranger is allowed to enter the contract between two parties. But the development of time, the law has also developed, and now even strangers are permitted to sue the safeguard his interests under exceptional circumstances. I hope this was an interesting topic and you got to know about the doctrine of the privity of contract. And the question that I would like to leave for my lovely viewers today is that, do you think the third party should be allowed to sue the other two parties if to safeguard his own interest? If you think whatever your answer is, you can leave in the comments below. And if you have any questions for me, you can leave that down in the comments below as well. Thank you so much for watching, and I hope you have a good day.